Strata reform will improve the management of strata. Reforms will do this by making strata managers more accountable, simplifying management processes, strengthening bylaw enforcement, and improving the maintenance of schemes. Currently, the Strata Titles Act does not refer to strata managers. Strata managers will be regulated by having statutory duties imposed on them. Strata managers will be required to act in the strata company's best interest, to hold minimum educational requirements, to advise the strata company of any conflicts of interest or commission received, and to hold the strata company funds in a trust account or within the strata company's own account. If the strata manager breaches a statutory duty or the contract, the strata company can serve a breach notice on the strata manager. The strata manager has 14 days to respond to the breach notice, stating what they will do to fix the breach and why the contract should not be terminated. If they are not satisfied with the response from the strata manager, the strata company can notify the strata manager the contract will terminate in 30 days. The contract will terminate in 30 days after the termination is served, unless the strata manager applies to the State Administrative Tribunal, or SAT, to review whether the contract should be terminated. If the strata manager's breach of a statutory duty causes the strata company to suffer a loss, the strata company can apply to SAT for damages from the strata manager. SAT will have the power to resolve disputes between the strata manager and the strata company. The reforms will also allow the use of electronic means to serve notices, keep records, and vote. Reforms will make it easier for the strata company to install solar panels and other sustainable infrastructure by passing a special resolution. Enforcing bylaws will be easier. Currently, preventing breaches of bylaws is not easy. If someone breaches a bylaw now, the strata company cannot get that person to pay a penalty unless the bylaw actually specifies that a penalty is payable. SAT can only order a penalty should be paid if the strata company can prove to SAT that the breach of the bylaw was willful and persistent. The reforms will mean that a breach of any bylaw may result in a penalty order being made. If a bylaw is breached, the strata company may serve notice on the person. The strata company can then apply to SAT for a penalty order against that person who committed the breach. Other reforms are aimed at improving the maintenance of the buildings within schemes. Schemes with 10 or more lots and smaller schemes which have a building replacement value above a specified amount will need to prepare a maintenance plan every 5 years, setting out their maintenance needs. Schemes with 10 or more lots will also have to operate a reserve fund. The strata company will have a duty to act reasonably. If a strata company does not maintain its common property, an owner can apply to SAT to order the strata company to maintain that common property. Other management reforms include that the strata council members will have a statutory duty to act honestly and in good faith. If they breach that duty, the strata council member may be removed from office. Getting enough owners to come to strata meetings is a problem. Reforms will allow those owners who are present at a strata meeting to declare a quorum 30 minutes after the appointed meeting time. This will not apply to two-lot schemes or to meetings where a special resolution, resolution without dissent, or unanimous resolution is required. Bylaws must not be unreasonable or oppressive. More information on the strata reforms can be found on Landgate's website.